One topic that came up again and again at IPBC Global 2016 here in Barcelona was culture and how a more constructive and collaborative culture needs to be established in the IP industry. Those were among the comments from our next guest, Murali Dharan from IPValue. There's a lot of commentary about how the US has lost its patent leadership. IP values are down, liquidity is down, the number of patent filings has fallen for the first time in goodness knows how many years. What will it take to bring it back to its former glory?
This year at IPBC is probably the first conference or the first time that recognition has become mainstream. In my conversations with many attendees at this year's conference, firstly, the recognition seems to be pretty pervasive that the U.S. has voluntarily surrendered its leadership in IP. It's important to realize that this is largely a self-inflicted wound. I don't think there's consensus on the value of patents, which is the broadest level of conversation that we need to have before the U.S. can start to reclaim that position. I think it's true for, at least the longest period of time, the living memory of anybody at this conference, the U.S. has had that leadership. And it's important to ask why that is. So clearly, rule of law is very, very important. And so the U.S. court system has functioned admirably in sorting out all these IP issues. And I think once there has become this uncertainty, partly policy-based, partly in the court system, I think that uncertainty has thrown things into chaos. And so that needs to get resolved. And I think fundamentally what needs to change is the presumption of validity around patents has to be brought back.
You spoke very positively about the US court system. You used the word admirably, that they had done an admirable job in sorting out.
Historically, yes.
But isn't it precisely those court decisions that have brought into question the rule of law, which you also said was one of the foundations? It's precisely because the court, in 25 or so cases, has reshaped the legal landscape that people don't trust them.
Well, it's not just the courts, but it's also the PTAB and the AIA and some of the changes in policy. It's the policy framework, it's the administrative court system, the PTAB, and then some of the court decisions about what is patentable subject matter. I think that part of the puzzle will get sorted out relatively quickly as to what is patentable, what about software patents, what about covered business method patents. I think those won't be open questions for a long period of time. And then you'll get back to this notion of, okay, let's say that we've done something to improve patent quality, whether it's, random spot checks on patents or some other process that the presumption of validity has been restored. If for example, we got to a place where 80% of patents on re-exams were upheld, right, then you would say, yeah, by and large, patents are valid. If on the other hand, you're below 50%, you would quickly come to the conclusion that, no, I can challenge any patent and no patent is really a valid patent. If you have that level of uncertainty, that's fundamentally a huge problem that the rest of the world isn't going to come to the US.
And some of our guests sitting in that chair have suggested that it's actually a cultural issue. That, we've had comments like, we need to stop kicking sand in each other's eyes and play well together in the sandbox. That the tone of conversation, who's bad, who's good, who's evil, who's not, needs to change, needs to be more collaborative. Would you agree that a change in culture is as much at fault, or perhaps the solution, than some of these legalistic issues?
I think that there are two different aspects that I see. Certainly there is a tone to the conversation, whether it's just going back to human nature, right? Let's just start there, right? Before you can kick somebody, the first thing that human beings do is stick a label on that somebody that you want to kick, right? It could be, I'm mainstream, you're not. I'm normal, you're not, right? I'm a producing entity, you're not. It's the same thing we've seen with the makers and takers kind of labeling. So the first thing is the labeling. So once you label a entity or a company as an NPE, then great. It's you can have a free for all, right? So that's how you've created a two-class patent system. You've created a two-class patent system by saying that patents owned by operating companies are somehow holier than the patents owned by quote unquote NPs. I fundamentally abhor the term because if you're trying to label behavior, it's one thing. If you're trying to label patents and try to segregate patents into Class A and Class B patents, that's fundamentally not going to work out well in the long run for the system.
So the language needs to change to a patent is a patent is a patent.
A patent is a patent. And the absurdity would be like, if you classified homes by homes that the owners lived in and homes that were rented, and you said if it's an owned home, you can sell it to another owner, but if it's a rented home, you cannot sell it, or you cannot sell an owned home to a firm that's going to rent it. I mean, ultimately, licensing is just collecting economic rent due for innovation due to the patents, right? And so if we have to agree on that fundamental principle level, right? But at the conversation level, we've got to get away from labeling and doing all that. I think we can all agree that certain behaviors are abhorrent and not, perhaps ethical, not good business practices, and we should be very clear about labeling such behavior, whether it's using litigation as a stick or a mechanism to create arbitration value or arbitrage value. There are certain behaviors you can abhor, but I think labeling as a broad class is part of the problem.